So I warmly welcome all participants, and first of all, I would like to thank the organizers for the honorable invitation to this event. Just a few words of myself, really a few words. I'm a Hungarian and European patent attorney. I am the third generation as a managing partner in our firm, SBGK Patent Attorneys, and I practice as a European and Hungarian patent attorney. So this would all of me. I will not say any more words because it's not so important. The important is what I have to say about the PCT system. So the purpose of my presentation today is to introduce you to a very beneficial form of the international extension of patent protection, the Patent Cooperation Treaty, which is also known as the PCT. Could I have the next slide, please? Okay, you hear me? Okay. Oh, thank you. Fantastic. So before we begin to study the system in a little more depth, it's worth to remember what a patent actually is. So I would say, in a sense, a patent is nothing more than a contract between the society and the inventor, according to which the society grants the inventor a monopoly for the exploitation of his invention for a specified period of time, while the inventor agrees that after the expiry of the monopoly, his invention becomes public domain, which means that everyone is free to use the patent. As we all know, the patent is a territorial right that it is only valid for the country in which it was granted, and it is also limited in time. The duration of the patent is in most cases 20 years. I say in most cases because, of course, there are some exceptions to this, but I won't go into that. So let's say the patent duration is in most cases 20 years. A patent is always based on a new and non-obvious invention, and as one of its main characteristics, a patent accelerates and promotes the technological development. Next slide, please. Okay, so how can I obtain a patent? I would say patent can typically be obtained in three ways. The first way is the national way. That means that we submit a patent application separately in each country, optionally by claiming a priority under the Paris Convention. For the second way, the regional way. That means the patent can be obtained also regionally, where the patent application is filed with a so-called regional patent office. And in this case, after a central granting procedure, the granted patent is validated in the corresponding contracting state. In such cases, the local patent offices give up their rights for examination, and the validation process is a mere administrative step, which means that usually the fees have to be paid, and then the corresponding validation request has to be filed with the local patent office. One very well-known example for this is the European way before the European Patent Office. So this is a European Patent Office, is a regional patent office, and the European Patent Application patent is a regional patent. But of course, other regional offices also exist. Can I have the next slide, please? Okay, thank you. So, in the third way, and by this we arrive at the point of this presentation, is the PCT way. So I can use the PCT system also. So what exactly is the PCT, or the Patent Cooperation Treaty? So the PCT is essentially an international treaty that promotes and facilitates the international extension of patent protection. This is a very efficient and advantageous system, but it is very important to note that this is a patent filing system and not a patent granting system. This system consists of two parts, an international phase and a national phase. The PCT has a total of 156 members up to date, which means that theoretically you can obtain a patent protection via the PCT extending to almost the whole world. Also, we all know that such a term as word patent per se does not exist. As an interesting fact, the youngest member of the PCT is Cabo Verde. It is a small republic of 10 volcanic islands off the coast of Africa, and joined the PCT on the 6th of April. So you can have your patent in very, very exotic territories as well. Could I have the next slide, please? Okay. This slide shows the timeline of the PCT international phase with the main events that occur during this phase. Although I will explain these events in more detail later, I wish to note at this point that this figure clearly shows that the PCT international phase is a very flexible process. And this is excellent for obtaining as much information as possible about the patentability of the international application, which can be used for significantly increasing the chance of the granting of the patents in the following national phases. Can I have a next slide, please? Okay, so let's take a closer look at the main features of the international phase. The international phase is a unified process during which the international application is filed and processed. The most important feature here for applicant is the fact that the application has legal effect for all PCT member states. That is, with the international application, the applicant can reserve the right to initiate a national application in all PCT member states in the future by maintaining the priority of the original application. Before the start of the national phases, the application receives a lot of information about the patentability of the application, part of which, for example, the International Search Report or ISR, becomes also public. One of the biggest advantages of the international phase, however, is that it delays the start of the national phases, which can have significant strategic and financial advantages. Next slide, please. So the international stage begins with the filing of the application. The application is received by so-called receiving office. What a surprise, which is typically the national office of the country, but the application can also be submitted directly to the International Bureau. Together with the filing, the relevant fees must be paid, and the desired ISA, the International Search Authority, must also be indicated. The application undergoes a formality check upon filing, and if the outcome of the check is positive, the application will be allocated a filing date, which is, of course, a very important thing. The next slide, please. Okay. So after filing with the receiving office forwards the application to the International Search Authority, which conducts the search. This search is carried out using the so-called PCT minimum documentation, the content of which is regulated in detail by the PCT. If I remember well, it's regulated by Rule 34 PCT. Please correct me if I'm wrong, but I think it's okay. So this regulation essentially defines which databases of which states or organizations must be used during the search and for what time period. The search provides a very good basis for getting a comprehensive picture of whether application satisfies the basic patentability criteria or not. And here, under basic patentability criteria, I mean a novelty and inventive step. During the search, all data that became public anywhere in the world prior to the international filing date of the application are taken into account. The ISA, as I mentioned before, is selected by the applicant, and when doing so, the applicant should take into account the quality of the search of the ISA in question. the related costs and the speed of the search, which was also touched upon by Johanna in her presentation. The most important ISAs includes, for example, the Visegrad Patent Institute, but I could also mention the Nordic Patent Institute, the EPO, or the US Patent and Trademark Office, and so on. During the international phase, it is also possible to have a supplementary international search later, which is optional and provides much more comprehensible information about the state of the art. The Visegrad Patent Institute, for example, also conducts such searches as mentioned before. Could I have the next slide, please? So on this slide, you see an international search report, an exemplary international search report. As you can see, this is a very clear and comprehensible document which provides applicants with a precise information about the documents held against the patentability of their application. This document is quite simple, where the first column shows the categories of the cited documents. Typically, the three letters shown here, the letters X, Y, and A, are usually found in these reports, where X denotes the document that is relevant to the novelty, Y is a document that is relevant to the inventive activity, while the letter A denotes a document defining the state of art in general. The documents are precisely defined in the middle column with the source and with the title, and of course with the publication date, because that's very important. While the third column indicates which claims the cited documents were considered to be relevant to during the search. Like I said, this is a really very simple and understandable document for everyone. Could I have the next slide, please? Okay, thank you. So the international search report is usually accompanied by a so-called written opinion. The written opinion is a preliminary patentability opinion which contains detailed reasoning why the application does or does not fulfill the requirements of novelty, inventive step, and industrial applicability. If the written opinion is positive for the application, it is a serious argument in terms of obtaining a final patent, and it will have a significant promoting effect later in the national phases. That means during the examination and grant procedures conducted before the national offices following the international phase. Obviously, everyone tries to move in the direction of the least possible resistance, and if a positive search report is available, which is also accompanied by thorough written reasoning, the examiners of the national patent offices are much more willing to work with this than to carry out a new complicated search and to begin with a long and complex examination. So actually, I would say that a positive search report and a written opinion is almost a full success, at least in my practice. The next slide, please. Thank you. So the international application is published 18 months after the priority date. At this point, the file itself becomes available to the public and thus becomes state-of-the-art, which is a key feature in terms of the evaluation of novelty and inventive step of patent applications filed after the publication date. A huge advantage of the international stage is that in case of an unfavorable search report and written opinion, it provides an optional opportunity to overcome the objections by amendments, and thereby we can obtain a favorable international preliminary report on patentability, or IPRP, before the national phases. This is very important. So this is the so-called international preliminary examination procedure, where the amended application will be examined and re-evaluated. The importance of this procedure lies in the fact that during the upcoming national phases, the favorable IPRP significantly simplifies the procedure before the national offices for the reasons I mentioned before. which means again reduced costs and increased chances of obtaining the patent. The international phase ends after 30 or 31 months from the priority date, depending on the national regulations of the individual contracting states. And after that, the national stages begin, during which the national offices carry out a separate examination and granting procedure. I have to note that the federal patentability opinion itself is not always sufficient for the desired success, which might sound a little contrary to what I said before. But that's due to different patent regulations of the member states. For example, agricultural methods are excluded from patentable inventions in India. Some other countries do not allow the patenting of smoking articles and so on. So there are some other obstacles which might stand in the way of obtaining a patent. But like I said before, generally a favorable ISR or WO or IPRP is really a strong argument for the grant of the patent. Could I have the next slide, please? Okay. In this slide, I would like to summarize the advantages of the PCT system. As I said before, it is very important to emphasize that the PCT system is a filing system, not a granting system, which means that during the international stage, no substantive decision regarding the status of the application is made. That means whether if it's refused or granted. Only patentability information is received, on basis of which crucial economic and strategic decisions regarding the invention can be made. The system is very simple because with just one application, we can obtain patent protection covering almost the entire world. It provides a cost deferral till the national phases, which means that we do not have to pay the national filing fees, translations fees, and agent fees, which are very significant costs. It provides early patentability assessment and also amendment possibilities, helping to minimize costs and maximize the chance of success. In addition, I would mention that the system also offers electronic filing and management options, which make the entire process cheaper and simpler. But this brings me to the end of my presentation, and I hope that you find all this information shared with you useful. And I also hope that this will allow all of you to be a little bit more prepared when filing an international application. Thank you for your attention, and I'm open to any questions you may have. Thank you very much.